Good morning, members of the jury. First, let me thank you for the attention that you have paid throughout the course of the trial. You certainly appreciate how important it is. I cautioned you at the outset that it was important that you pay attention to the evidence as it was presented, because you would have to rely upon your recollection at the end of the case in rendering your verdict in the case. You, the members of the jury, play a very important role in our system of justice. You are the triers of the facts. You are the ones who have the responsibility to determine what the true facts are. Whenever there is a dispute or controversy in the testimony which has been presented, it is your responsibility to resolve those disputes. When you walk into a jury box, you bring with you your common sense and experience, and you apply that common sense and experience in resolving the disputes and in determining what the true facts are. In your everyday experiences, you learn to judge and to assess what is said to you by people. You do that by judging their demeanor. Do they appear to you to be trying to be accurate and truthful? Or do they appear to you to be evasive? Well, you apply those same tests here in determining which way to resolve the disputes. You judge by demeanor. You judge by whether what the people have told you from the witness stand is consistent with other events that have been presented to your satisfaction, whether it fits in and makes sense, or whether it runs completely contrary to common sense. You use that judgment. Another judgment that you will make is whether the particular person who has testified has a particular interest in the outcome of the proceedings. You have heard a number of witnesses testify. You have heard Sergeant Woods testify, and you will have to judge whether he has an interest in the outcome of these proceedings, as has been argued to you by counsel. One of the defendants testified, and quite obviously the defendant has an interest in the outcome of the proceedings, because it is his guilt or innocence that is before you for consideration. Now, the fact that a witness has an interest in the outcome of the proceedings does not necessarily mean that that will in any way influence what that person has testified to. But it is a factor that you must take into account. You apply all these tests, members of the jury, in determining whose versions of the events you are going to accept. You make those determinations based upon the evidence. Counsel have presented arguments to you. Arguments of counsel are not evidence. They are what the name implies. The arguments made by an advocate on behalf of the government on the one side, and on behalf of the defendants on the other side. It is right that you listen to their arguments, so long as you bear in mind that it is for you to determine what the facts are, and that it is for you to determine what inferences you should draw from the evidence that has been presented. It is proper for counsel to argue to you that you should believe this witness and disbelieve that witness. You should draw this inference and you should reject that inference. That is all proper. But you must bear in mind, it is your responsibility and your responsibility alone. If counsel has recounted some of the evidence, or if I recount some of the evidence to you, and if counsel's memory or mine differs from your collective recollection of the evidence, you reject counsel's and you reject mine, because it is your collective recollection which must govern. You are supreme when it comes to the fact-finding. When it comes to the law, however, members of the jury, you are not supreme. You are to be guided by the instructions that I give you in the course of this charge. That is why it gets the name charge. I charge you with these principles of law that you must apply. You can't pick and choose which principles to apply. To do so would be a violation of your oath. You must apply all of the principles of law that I give you to the facts as you find them in arriving at your determination of guilt or innocence as to each of the defendants who is on trial. It may be that at the end of your deliberations or during your deliberations, you may have some confusion about what I have said to you as to the instructions in the law that you are to apply. If that should happen, I want you to prepare a note and send it back to me, setting forth what your question is. Now, I hope you won't be asking me to remind you what the evidence was. As I told you, you are supreme in that regard, and it is your recollection which should govern. Your question, I hope, if you should have one, will address itself to the principles of law that I have given to you, in which case I will then bring you back and give you more instructions. Incidentally, juror number 1 will be the foreperson of the jury, unless juror number 1 does not desire to act in that capacity. If he does not desire to act in that capacity, then you may elect someone else. Now, this case is a criminal case, and it is important to both sides. It is important to the government. It is important to the defendants. This is their day in court. Each is entitled to have the case considered on the law and on the evidence which has been produced in this courtroom, without sympathy for or prejudice against either side. Now, your verdict must be unanimous. Unless and until all 12 of you agree on a verdict of either guilty or not guilty, it will be your verdict. All right, 9 minutes at 1:20.